Happy New Year. Welcome to our first congressional briefing of 2023. We're starting off on a bang this year by diving off into the absolutely groundbreaking victory of 5 activists and academics against a totally baseless lawsuit filed by the US-based Hindu right-wing group, Hindu American Foundation, or HAF for short. This lawsuit was given a complete smackdown by Judge Amit Mehta of the District Court of Washington, D.C. in a phenomenal ruling that we'll be taking an in-depth look at today. This ruling is pretty much a slap in the face against organizations that want to harass and silence their critics, and it's a major win for those who push back against these groups and their divisive ideologies. Now, if you haven't been following the case, here are the highlights. In 2021, Al Jazeera published 2 news stories. One was titled "Hindu Right-Wing Groups in the U.S. Got $833,000 of Federal COVID Fund." The other was titled "Call for U.S. Probe into Hindu Right-Wing Groups Getting COVID Fund." These 2 stories included quotes from activists who stated that the Hindu American Foundation, along with 4 other U.S.-based Hindu groups, had, quote, ties to Hindu supremacists and religious groups, quote, and named HAF as one of 5 US-based front organizations for Hindutva. This is all in quotes, by the way, just throwing it out there. For Hindutva, the supremacist ideology that is the driving force behind much of the persecution of Christians, Muslims, Dalits, and other minorities in India, end quote. Soon after these stories were published, the Hindu American Foundation filed a defamation lawsuit against IAMC, Indian American Muslim Council, Executive Director Rashid Ahmed, Federation of Indian American Christian Organization, or FIACONA, Chairman John Prabhudas, and Hindus for Human Rights co-founders Sunita Vishwanath and Raju Rajagopal. HAF's accusation was that these activists, all of whom have a long history of advocating for the rights of Indian minorities, had, quote, conspired to publish allegedly false and defamatory statements about HAF in the Al Jazeera articles. And Rutgers professor Audrey Trushke, who is also here with us today, who shared the article on Twitter along with a personal story of being targeted by HAF, was also included in the lawsuit. Now, in simple terms, these 5 individuals had criticized HAF and HAF didn't like it, so they decided to slap them all with a lawsuit which Judge Mehta then tore to shreds in his ruling. Excuse me. Like I said before, we're taking a deep dive into this case, and we're going to break it down to see what exactly Judge Mehta said and what this means for activists across the country who are pushing back against Hindutva. We're joined here today by the defendants in this case, and you'll be hearing from all of them. But first, I'd like to introduce you to their esteemed attorneys who played a major role in winning this case, and they will be explaining the implications of the case and legal details for us, the layman. So here we've got with us today Joshua Colangelo Bryan, who practices in the areas of criminal defense and complex civil litigation with Dorsey and Whitney. He devotes a substantial portion of his practice to pro bono matters, including the representation of Guantanamo Bay detainees, the representation of victims of an attack by Turkish security personnel in Washington, D.C., and as a consultant to Human Rights Watch. He represented Mr. Rashid Ahmed in this case. Mr. Tom Sullivan is a partner in the media and entertainment group of Ballard Spare LLP based in New York. He represents media companies and other clients in defamation, invasion of privacy, access, intellectual property, and other content-related matters. Among other recent cases, Tom served on the team which successfully defended the New York Times and its former opinion editor, James Bennett, at a trial against defamation claims brought by former Alaska Governor Sarah Palin. He represented Sunita Vishwanath and Raju Rajagopal in this case. And lastly, we have Dan Sullivan, who is a partner at Howell Schuster and Goldberg LLP in New York. Before joining in 2014, he worked at Gibson Dunn and Crutcher in New York and clerked first for Judge Diarmid O'Scanlan of the U.S. Court of Appeals in the Ninth Circuit, and then for Justice Scalia of the U.S. Supreme Court. His practice focuses on both complex commercial litigation on the one hand and appeals covering a broad area of subjects on the other. He has handled appeals in the 2nd, 7th, 9th, 11th, and federal circuits at the federal level, and in state appellate courts in New York, Georgia, West Virginia, and Nevada, and he represented John Prabhudas in this case. I know those were long bios, but honestly, I had to introduce the gravitas of these gentlemen. So thank you all so much for joining us today. And it's a big pleasure to have you here. I'm going to jump into questions, and I'm going to start with you, Josh. So can you tell me, in layman's terms, what exactly was this case that HAF was trying to bring against these activists, and what were the defendants being accused of?
So, put most simply, the plaintiff HAF claimed that Rashid Ahmed, our client, and the other defendants had made defamatory statements in connection with these two Al Jazeera articles. To us as lawyers, and I appreciate the plug, but I think even first year lawyers should have gotten this case dismissed because it was so bad. The flaws were really evident as soon as you looked at the complaint. For example, Rashid, our client, was accused of defamation because he had said people should be concerned if taxpayer money funds hate groups. Now, I personally agree with that, but maybe there are people who don't. Either way, obviously that is a statement of opinion, which he is perfectly entitled to make, as Judge Mehta ultimately found. Looking at the complaint at the very start of the case, it also was clear that HAF did not actually contend it had suffered any financial harm. And in fact, Judge Mehta later found that there was, quote, little, if any, close quote, evidence that these statements had resulted in any financial loss to HAF. Now, you can't sue someone for damages if you haven't suffered any loss, but that's exactly what was going on here. And just by way of further example, as you described, the case arose out of a couple of articles in Al Jazeera. If you think a media company has defamed you in 2 articles, well, don't you sue the media company? But obviously that didn't happen here. Instead, we see directors of nonprofits and academics being sued. Obviously, it's easier to intimidate people with a lawsuit if those people don't necessarily have unlimited budgets to defend themselves in court. Of course, Al Jazeera probably has an unlimited budget, but the people who are actually sued here clearly do not. So for us, as soon as we saw that in the complaint, it was clear that the litigation wasn't brought for legitimate purposes, but instead to silence people. As lawyers, we tend to believe in the First Amendment. And so, for us, it was an easy decision to take the case for all of these reasons that ultimately were validated by Judge Mehta when he threw the case out.
I'd actually like to follow up on that. So Josh, you touched on why your firm decided to take this case. I'd like to pose that as well to Tom and Dan. Why did your firms choose to take this case as well?
I think from our perspective, we routinely represent large media companies, companies like Al Jazeera that Josh was just talking about. And it's not that common for individuals who are interviewed in an article to get sued. From our perspective, it was an important, we have a pro bono commitment to all kinds of cases, but for our people in my group, the media group, we particularly have a pro bono commitment to these kinds of defamation or copyright cases. And it seemed like this was an attempt to go after folks who were uncommon targets of these suits. And it just seemed like the right thing to do to protect people from an attempt to silence them and to shut off a side of debate about a political issue and to go after your political opponents.
Appreciate the answer. Dan, how about your firm?
Sure. And thank you, Safa, for the introductions and for arranging this briefing. I would agree with everything that Josh and Tom said. And I think that, in particular, just by reading the complaint, I think Josh made this point, it was immediately apparent what was going on here and what this lawsuit was, that it was an attempt to silence HAF's critics. We're unlike Tom's group, we're not specialists in media law or in defamation, but it was even for a humble commercial litigator like me, it was so clear what was happening here. And we do all kinds of pro bono cases in a variety of contexts, and this one jumped out at us as a particularly worthy cause.
Thank you. And let's make this clear for our audience what exactly was wrong with the case. So we're going to go into the nitty gritty now. Judge Mehta was incredibly thorough in his rulings. So what I'm going to do is pull some of the highlights of his statement and have you explain them to me. Now, the court used a good amount of ink, telling half that most of the defendants don't even fall under its jurisdiction anyway, and we'll touch more on that later. But then Judge Mehta follows up by saying that there was no defamation in any kind of way from the defendant's statements. Tom, I want to turn to you. Can you give us some background real quick? What counts as defamation in the United States?
Sure. So, the First Amendment is the foundation of protection against, not very good defamation claims in the United States. And over the years, the Supreme Court has established, several important protections. The first of those is an incredibly high standard when you're talking about a public figure. If your speech is about a public figure or a public official, the plaintiff has to show that the statement was made with what's called actual malice, which is either knowledge of falsity, so that you are knowingly lying, or at the very least, serious doubts about what you're saying is true. And those serious doubts don't just mean you're not sure. It means that basically somebody is waving their hands in their face saying this is wrong, and you run away so you don't hear it, like a little kid, and so that you have serious doubts about what you're saying is true or false. So that's number one, and that's a very high bar. It's hard to meet. It's a bar that HIF didn't meet here. And the other one is that you can't be sued for statements that are statements of opinion. They have to be statements that can be proved true or false, because otherwise you'd have lawsuits all the time like this one, where there may be matters about which reasonable minds can differ, but that political debates or differences of opinion shouldn't become automatic lawsuits. And I think that's a thing here. The other basic elements are you need to have published the statement at issue. There's no question here that at least most of the statements have been published, though the way they tried to plead it to suggest that different individuals were responsible for statements that somebody else had made could have potentially been an issue here that the judge ultimately didn't reach, but could have been an issue. And finally, the statements have to be false. I can say something about you that is incredibly damaging of your reputation, but if it's true, I have absolutely every right to say it. You can't be penalized in the United States for a horribly reputation damaging statement that is entirely true. And I think that is another issue here that we didn't get to, but I think if the case had gone forward, would have been an interesting issue to litigate.
Got it. So on that note, Judge Mehta says clearly that half fails to plead actual malice against defendants Vishwanath, Rajagopal, Ahmed, and Trashki. And then he later adds that the accusations of defamation against John Prabhu Das also fall far short of the daunting standard of actual malice, end quote. He also says that the court, quote, cannot possibly infer that any of the defendant's statements were made with actual malice, end quote, because, quote again, most of the statements are clearly statements of opinion. Now, Dan, two questions from this. We've already covered what actual malice is, but why did Half utterly fail to make that claim? And the second question is, what does that say about what was really going on in Half's lawsuit?
Yeah, sure. So as Tom said, the standard for actual malice, and as the judge said, the standard for actual malice is a daunting one, and that's by design, because the whole the balance that that is struck between the protections of the First Amendment and defamation claims is one that essentially says that if you engage in public debate on an issue of public concern, you have to be prepared to take a little bit of heat. You have to be prepared to take a little bit of criticism. That's fundamental to kind of the civic order in this country. And so a public entity like Half can't complain about criticism unless it can show that the person who criticized it not only said something false, but said so knowing essentially full well or all but knowing that it was false. The factual allegations in the complaint that HAF made to support its to show actual malice were very poor. They essentially said, well, you could have looked at our financial disclosures, which would show, so say they, that we didn't get money from organizations in India tied to Hindutva or far-right Hindu nationalists, and therefore you should have looked at those documents, and had you looked at those documents, you would have known that the statements were false. Now, there are a number of problems with that theory, and I'll get to a couple of those, but just taken on its own terms, right? The law is pretty clear that even when it comes to a news organization, when it comes to journalists, if you say, well, there was evidence out there that you could have investigated that would have shown you that whatever you put in your news report wasn't true, that's not enough to allege actual malice. Supreme Court has said that several decades ago. So that was essentially the kind of allegation that was made here. So from a strictly legal perspective, I think it was pretty easy for Judge Mehta to find that they failed to allege actual malice. What was also interesting, though, I think about this case, and again, it just jumps out at you when you read the complaint, is what they didn't allege was false. I mean, they were right. Not only did they not sue Al Jazeera or the author of the article, but there were a lot of concrete facts. Now, just going back and looking at what some of them were that were in the articles that they didn't even contest, that went to both the failure to plead falsity and I think also the failure to plead actual malice. So they didn't contest that HAF's treasurer is the son of the national vice president of the U.S. wing of RSS, right? They didn't contest that his family had donated a significant sum to HAF in 2018. They didn't contest that a co-founder of HAF was formerly associated with an affiliate of RSS. They didn't contest that HAF had defended the Indian government's passage of legislation that the United Nations described as fundamentally discriminatory. So those are just things that we noted in our papers, and there were statements made in the articles to that effect. They didn't claim that any of that was untrue. So when you see that, and instead they're saying, well, you should have looked at our financial statements, and that would have falsified your effectively statements of opinion, it makes for a very weak case of actual malice. I touched a little bit on falsity there as well, so sorry if I trenched on the next question, but the two issues are related to some extent.
Thank you so much. No, that was great detail. Now going back to Josh, there's another portion of HAF's lawsuit where they allege conspiracy, claiming that the defendants all got together and conspired to publish these defamatory statements. Now, conspiracy is a loaded word, and HAF claimed that the defendants did conspire to defame Hindu American Foundation, but Judge Mehta responded by saying that HAF comes, quote, nowhere close to making a valid conspiracy claim. Now, what does conspiracy claim mean? Because I think when most of us think conspiracy, we think Pizzagate, but in legal terms, what does that mean, and why did HAF's allegation get thrown out?
So in this civil as opposed to criminal context, it's essentially the idea that people acted in a coordinated way pursuant to an agreement to do something improper that could be the basis of a civil lawsuit. I think Judge Mehta's decision, which was so definitive on this as well as other points, really emphasizes the fact that HAF simply made this idea up. It could not point to anything at all to suggest in any way that the defendants had agreed to do anything, let alone defame HAF. So you're right that it's a very loaded term. And particularly if you hear it as the target of a government investigation or a defendant in a criminal case, it can be terrifying. Here, it was of absolutely no effect because there wasn't the slightest factual basis for it. So it's just another piece of the litigation that was obviously frivolous on its face from the moment this complaint was filed.
Got it. And back to Dan really quickly. All of the defendants fall outside of the DC court's jurisdiction for this case, except for your client, John Prabhudas. Now, how did that impact John's case, and what were the stakes for him?
Sure. Well, most simply, it meant that we had to win on the merits, right? So it's always good when you're a defendant in a litigation to have a number of layers of armor if you can get it right, and to have a couple of credible arguments to make. This was an embarrassment of riches on the merits, but it was also an embarrassment of riches for John's co-defendants, who also had arguments based on personal jurisdiction. Now, we also had arguments based on Half's failure, in our view, to plead that there was subject matter jurisdiction over the case, which is a technical issue, federal court jurisdiction. Judge Mehta ultimately found that they just barely got over the line for purposes of pleading, even though he cast a lot of shade on the ultimate facts of whether or not they were going to be able to show that there were really harms exceeding $75,000 at stake in the case, which is what you need to get into federal court when you're bringing state law claims, like defamation is a state law claim. But in any event, for us, for John, it was really going to be on this motion a fight on the merits. And when I say the merits, I don't mean whether or not the facts alleged were true or false, right? One thing to keep in mind is that procedurally, this is just at the complaint stage. This is like dismissal at the earliest possible stage of the case. What the judge is saying is, even if all of the actual facts alleged, and that means the judge doesn't look at conclusory statements, doesn't look at the labels that are put on things, but if all of the facts alleged are true, would that be a claim? Would that be a legally recognized claim? And he said no. So that's a pretty strong thing for a judge to dismiss a case outright. So it's not that we were trying the case on the merits, but when I say on the merits, I mean the question of whether or not Half had properly alleged a defamation claim that John or anybody else could be liable for. And of course, the answer was no. So yeah, for us, it was we kind of had no choice but to get, putting aside the subject matter jurisdiction question, we had no choice but to get right into the weeds of the actual claim as it was alleged against John. Now, on the flip side, there were, the claim, such as it was against John, amounted to one quote in one of the articles and a tweet. So, and the quote, I have it here just to remind myself, was that government watchdog groups, as well as human rights organizations, need to take serious note of the misappropriation of COVID funding by Hindu supremacist groups in the United States. That's the basis for a defamation claim. It's eyebrow raising, to say the least. And Judge Mehta threw that one out on a number of grounds that we can get to, but the ones that we've discussed: failure to plead actual malice, statement of opinion, etc.
Appreciate the answer. Now, going back to Tom, now Hindu American Foundation has been suggesting, they put out a PR recently that, pointing to two footnotes in the ruling, claiming that Sunita's and Dr. Treshke's statements were verifiably false. However, if we look at the text of the ruling itself, Judge Mehta had actually said that Sunita's statements were plausibly verifiably false, and Dr. Treshke's statements were arguably verifiably false. Now, for me, that's a lot of legalese. So can you break this down and explain what was the judge really trying to say? And does this suggestion on Half's part that they had a moral victory of sorts and that the suit was dismissed on procedural grounds. Does that hold water?
No, I can end it right there. No, as Dan was suggesting a few minutes ago, on a motion to dismiss, the standard is, has the plaintiff stated a plausible claim? The judge isn't making any sort of call on whether the claim is actually good or not. It's just, is it enough to get over this sort of first hurdle? And the judge found that it wasn't. With the exception of these two statements he mentions in the footnote, he found they were plausibly, verifiably false. What that means is that potentially those are statements that could be proven true or false. So, it is possible for one of the statements was that HAF has has a parent organization. And he found it could be proven as a matter of fact whether or not it has a parent organization. He did not find that it doesn't have a parent organization. He made no ruling on that whatsoever. He just found that someone, somewhere, at some point, could potentially look into it and say, it does or does not have a parent. That's it. So it wasn't a ruling that anybody said was false. It wasn't a ruling that any of the defendants in this case lied. It was a ruling that potentially, if the case was going forward, which it is not, because all of the defendants won on multiple other grounds, that could be proven true or false. It's just, he found that wasn't a statement of opinion that therefore was kicked out on that additional ground. And so to the extent they're saying that's some sort of moral victory, it is not. It is it's just saying that it's something that conceivably could be proven true as a matter of, logic, not that it is actually true or false.
Got it. So I appreciate that clarification. And I want to pose this to our other attorneys as well, because some of HAF's supporters have been outright claiming that the judge found that Sunita and Dr. Treshke both lied. And I would like to know, Josh and Dan, what are your thoughts on that sort of, defense in retrospect?
As Tom said, the judge found that theoretically, it's possible under the laws of science to one day determine if those two statements might be true or might not be true. Although he also said, even if true, I don't really think it would be defamation. So it's the tiniest of legal points that normally nobody except a lawyer would find interesting. But here, the fact that HAF has homed in on that just shows the desperation to find some manner of silver lining. I think the same can be said for the point that HAF has made repeatedly about this being merely a procedural victory. Now, when we talk about procedural victories, that's the issue of there being no personal jurisdiction over 4 of the defendants, which HAF should have known at the very beginning of the case. But you can call that a procedural victory. What HAF ignores is that the court then went on and said, oh yeah, but what those 4 people who are outside the personal jurisdiction of the court said, that's just opinion. It's Rashid Ahmed saying, hey, let's be concerned if taxpayer money is going to hate groups. Those statements, the court said explicitly, were not defamatory. So the idea that the court limited its opinion to some narrow technical ground, you can only believe that if you ignore the second half of the court's opinion, which HAF seems to be doing, and I guess is fortunate that courts are not able to sue for defamation when their opinions are mischaracterized by litigants.
That's a great point. So just for the record, so we can really hammer this one in, you're saying, or all of you are saying, that the judge did not find that Sunita and Dr. Treshke lied.
That's correct.
Okay, got it. Thank you so much. So on that.
Sorry,
Oh yeah, go.
and I agree with everything that Tom and Josh said, of course, but it is remarkable to me that that HAF has kind of put the spin on the lawsuit that it has, or maybe it's not so remarkable, I don't know, but because it's pretty fundamental that in a defamation case, right, which is supposed to be about someone lying about you to the press or in public, that for the vast majority of the statements that they made the basis of their complaint, they weren't even statements that could be lies, because they were statements of opinion, because they were things that couldn't even be objectively shown to be true or false, right? It's like, I spend a lot of my time, litigating securities fraud cases and other sort of commercial fraud or misconduct cases. And I can tell you, when you're alleging, that someone has made a misstatement, one of like the basic things that you do is make sure that the statement you're saying is false or fraudulent is capable of being proven false or fraudulent. It's like 101, right? So the remarkable thing is not that there were a couple of statements in there that he could say, well, those could be proven objectively true or false. What's remarkable is that the vast majority of the statements that they made the basis of their complaint cannot be. The big picture to me is that, Judge Mehta's ruling is very even-tempered and judicious in its tone and in the way that he described the case, but he left no doubt, I think, in the mind of any sort of legally literate reader that the suit was really a frivolous one. So I just wanted to weigh in because I find it remarkable that they put that spin on it. But anyway.
I actually do want to come back to that point in just a minute. Also, I apologize if you can hear rain on my end. Yeah, but just ignore it. But I did want to ask about one other thing HAF has suggested, where there's a part of the ruling where Judge Mehta mentioned tortious injury, and HAF seems to have interpreted that as the judge verifying that HAF has been injured by the defendant's statements. Now, Tom, is that an accurate representation of the judge's claims, or is that a mischaracterization?
That's, again, not what the judge was saying. That section that they cite comes from the discussion of the personal jurisdiction issue that we just talked about earlier, the issue of whether any of these defendants, with the exception of John, could actually be sued in the District of Columbia, because most of them have absolutely nothing to do with DC. They don't live there, they don't work there. And as part of that discussion, the judge found that if there was an injury, assuming there was an injury, that injury would have had its impact in DC, because that's where HAF is located. But that's what he's saying in that section. The judge made no finding that HAF was injured by any of these statements. And as Dan was mentioning in a separate section of the opinion where he talks about subject matter jurisdiction, he found they barely came over the line of even pleading an injury. But no, the judge did not find that these statements injured HAF. He was just saying that if they were injured, the injury would have been felt in DC where they were located.
Okay, I see. Appreciate the clarification there as well. Now, I'm going to pose one more question to all of our attorneys. How would you describe this ruling? Would you say that this sets a new precedent, or does it affirm what has already been legally established? And lastly, what effect do you think this ruling will have on other organizations similar to HAF who might be looking to harass their critics? I know that's a big one, it's a loaded one, but feel free to answer whatever part calls to you most, I guess.
I'll say a couple of things first, so the legal heavyweights, Dan and Tom, can finish us off at the end. I don't think that the judge really plowed any new ground. I mean, the basic, most fundamental failing of the lawsuit was, if someone expresses a view, you don't get to sue them for defamation. As Tom described, we all know that as lawyers. HAF should have known that before it ever put pen to paper on this lawsuit. So in that way, it's not a novel opinion. it is absolutely the result that should have obtained. I think what the opinion does is serve as a powerful reminder of that principle, and hopefully would discourage other potential litigants who want to try a lawsuit to shut people up from taking that approach.
Thank you so much, Josh. Tom and Dan, would you like to chime in?
Sure. I think I agree with Josh on it doesn't plow a ton of new ground legally, I think, because these claims were, not very good claims. I do think the two things that helps somewhat going forward, it's fairly uncommon to sue the group of people who are quoted in an article for a defamation claim. And I think the attempt to plead that just because all these folks were quoted in an article together and are frequently parts of, coalitions together, that's somehow a conspiracy. I think that does set, I don't think any of that was true before, but I think it's good to have that laid out somewhere, because I do think this happens, that people do get quoted, in an article together, and it doesn't mean that they're all working together to some, evil end. And the other thing I would say is the case law was good on the opinion issue, but hadn't been applied. It had largely been applied to anti-Semitic groups and racist groups. And I think having it make it clear, as it should, that applies to opinionated statements about a broader selection of, right-wing or extremist type statements, I think is helpful, just to make clear that is also opinion. I don't think any of that's surprising, but it hadn't necessarily been applied in this type of context before.
Thank you so much.
I mean, I think it's a cautionary tale, for folks who might want to, in my view, abuse the legal system to intimidate their critics. I think, in a way, the greatest significance of the decision is that it came out the way it did. In other words, it would have been very, very significant and very troubling had the lawsuit been allowed to proceed, particularly because, again, it is against individuals who, don't have the wherewithal of, large media companies, as Tom said at the beginning, to endure, all of the stresses of a lengthy litigation, to say nothing, even though we were all working on this case pro bono, it's stressful and it's time consuming as an individual to be subject to a lawsuit like this. And even if the judge had said, well, I got to kind of let this go, and it's sort of enough, I think that it would have set a troubling precedent, because it would have opened the door to that kind of intimidation. So I think it's important that the judge reaffirmed all the principles that Josh and Tom were referring to, and it's again, his opinion, I think, is very clear that we're supposed to have a wide open debate about ideas under the First Amendment in this country, and that means bearing even aggressive criticism. This criticism wasn't, frankly, even that aggressive, and I think, especially in the current climate, upholding the importance of that principle is very valuable.
Thank you so much, Tom, Josh, Dan, all of you, for not only joining us here today and sharing all your insights, but also for all the great work you've done on this case. Really appreciate you being here. I will come back to you towards the end, because we've got some great questions in the Q&A chat box for you. But right now, I want to turn to our defendants, all of whom are here with us to share their side of the story. And now I want to turn to you all and talk about exactly what it feels like to be caught up in a lawsuit this large and potentially damaging. And I'll go through and introduce all of them for our audience. We have here with us Mr. Rashid Ahmed, who is the Executive Director for Indian American Muslim Council, Raju Rajagopal and Sunita Vishwanath, who are the co-founders of Hindus for Human Rights, an organization that advocates for pluralism, civil and human rights in South Asia and North America. We have John Prabhudas, the chairman of the Federation of Indian American Christian Organizations, abbreviated as FIACONA, a national umbrella organization of Indian American Christians and of those who are interested in issues affecting Indian Christians. And lastly, we have Dr. Audrey Trushke, who is Associate Professor of South Asian History at Rutgers University, who, in spite of being the target of extensive harassment from Hindu extremists in both India as well as in the United States, remains unapologetic and outspoken in her criticisms of Hindu extremism and the current Indian government. Thank you, everyone, for joining us today. And first of all, big congratulations for winning this lawsuit. This is absolutely amazing. And we're so happy to hear that you're past all the stress and all the turmoil that might have come with it. So very happy for all of you. And yeah, I just want to talk about, now that we've covered all the legalities, now that everyone knows the impact of this case, like what is the emotional weight of this for all of you? So Mr. Ahmed, let's start with you. So when you found out that you were named in this lawsuit, what was your initial reaction, and were you surprised at all?
My initial reaction was to go back and read what I said. And it was simply like Josh said, that I expressed my opinion that taxpayers' money should not be given to the hate groups. And the more I thought about it, then I began to wonder if half thought that they are the hate groups. That's why they are suing me for saying that. But again, I mean, obviously it has been stressful for especially, for my family, my children, my wife. It was a whole new experience. I have never been sued. Although my father was attorney, I know the legal in India. I know the legal space. What happens in some ways closer than others probably. But all I can say is that what Dan mentioned, that's one of the best outcome, I guess, that there is a precedence. If Judge Mehta would have let it continue the trial, it would have been a serious setback to the principle that all these attorneys have fought for. And I also want to thank not only Josh, but other Dorsey legal team, Brianna and Dan, for being so amazing support and explaining what the legal case is, and also at the same time comforting in the way that you have not done anything wrong. So I appreciate and thanks from bottom of my heart. Josh, please convey my gratitude to Brianna and Dan. I know there's a lot more. We don't have much time. I don't want to make many comments, except that for some of those who don't know, in India, the Hindu far right ecosystem has a lot of groups like Proud Boys and Patriot Front and Act in America, like that. In India, because of the social environment or social construct, in India, all these Hindu far right organizations, equivalent to Proud Boys and Patriot Front, etc., they actually have physical violence. They actually can, go through physical violence from all the way up to killing and get away with that. So I think half probably forgot that they are in America, not in India. So instead of, physical violence, they're using the legal violence. It's like, the legal lynching of anybody who wants to have a difference of opinion from them. So I thought that was interesting from half how they made this decision. As an executive director of nonprofit, and also I have done a lot of consulting in the nonprofit board, development and all that. If any nonprofit whose executive director has presided over such a slap a frivolous lawsuit and spend hundreds of thousands of dollars the donors gave for something else, I know the executive director would have been fired by now. I know my board would have fired, especially if I was attorney. So I just don't understand half's board and half's donors, where they are coming from. Is it just hate? I don't know. So maybe that's why they got upset when I said that hate groups shouldn't get it. So it's just baffling anyway. Before I end, the other comment is maybe a little bit humorous, but I thought it was humorous. One of my friends called me after he saw the news. He said, I heard that the lawsuit that have filed has been dismissed. So he suggested you shouldn't call them half anymore. You should call them quarter, because they have reduced. So I thought that was kind of funny. But anyway, thank you again for all the attorneys, Thomas and Dan also. Thank you for all that you have done.
And thank you, Mr. Ahmed, for sharing. I saw the joke and all the other comments you made. I think the term you used, legal lynching, was very powerful, especially. And I do want to turn now to Dr. Trushki. You never even said a word about HAF in those Al Jazeera articles, and yet they went out of their way to include you in their lawsuit. And you did chronicle what was going down throughout that time period on your Twitter. Now, I would just want to know, what did you think were the things that stood out most to you about this lawsuit? And yeah, as someone who has experienced extensive harassment from the Hindu right wing, what was that experience like, being now directly sued by this massive organization?
Thank you so much, Safa, for the questions, and thanks to everyone for being here. So I said nothing in those Al Jazeera articles, right? I wasn't quoted at all. I simply read them on Al Jazeera and shared them on social media. My initial reaction when we first all got the cease and desist letters, which HAF publicized, was, who are all these people? I was not familiar with multiple of the people who had gotten those cease and desist letters, right? That was 6 individuals plus Al Jazeera. Only 5 of us were in the end and part of the lawsuit. But John, I don't know if you remember when we eventually got sued and I called you up and I got your number from someone and I was like, hey, John, this is Audrey, your alleged co-conspirator, like, good to connect. Because we had never met, still have never met, and had never spoken before. I think another reaction that I had initially is similar to the one that Rashid mentioned, which is just, thank God we're in the United States. Right? The Hindu right has assassinated numerous professors in India. Many are rotting in jail. In India, defamation can be a criminal matter. Indian courts don't bail a lot. So, like, thank goodness we're in the US. But then my thoughts quickly turned to, well, this is going to complicate my research going forward. I had begun a project on the US-based Hindu far right in early 2021. I was very public about that research. And I was also rather public in that context about the fact that I was focusing on HAF as sort of one kind of central node of my work. So they knew that when they sued me, in my opinion, they sued me to stop my research. There was simply no other reason to include me in this lawsuit. And I worry about the effects. Close to 2 years later now, more than 2 years now after I began my research, on the one hand, I continued my research throughout the lawsuit. I've published more than 6 articles on the US Hindu right, including numerous that mention HAF during the course of this lawsuit. So on the one hand, I am thrilled to say that their attempts to silence an academic and to infringe on academic freedom did not work. That said, it's obviously horrible to go through this. It was stressful for me. It was stressful, especially for my 3 young children. Not that they understood the intricacies, but they understand when mom is upset and has a lot on her plate. And so I worry about that precedent and other academics looking at that and being like, don't know if I want to go there. On the other hand, I will note that 2022 was a banner year in terms of academic scholarship. on HAF in particular, and on the US Hindu right more generally. I've never seen more writing on HAF than I have in this year, and only a fraction of that was from me. So I think going forward, this might actually have the inverse effect, right? Something known as the Streisand effect, a reference that our attorneys will get there. So maybe that's a silver lining to all of this. But I think for me, this is the last thing I'll say, it does complicate my positionality going forward. And that's something that I'm aware of and that I have been aware of since receiving the initial cease and desist letter, is that regarding the US-based Hindu right, I'm always going to be part of that story now, in addition to being an academic observing and analyzing that. It's not necessarily a good or bad thing. It's just a thing that complicates my perspective.
Thank you so much, Dr. Treschke. Really appreciate your comments on this, and good luck with your research, and I hope it continues unhindered. I would like to turn now to Raju and Sunita. So both of you are co-founders of Hindus for Human Rights, and you are leaders in the space where you are trying to appeal to the Hindu American public and speak about the human rights elements of all this. Now, for Hindu American Foundation to come out and sue you for this and claim that you are part of attacking Hinduism, which is a stance they've taken many times because you criticize Hindutva, the ideology. What are your thoughts on that? Either one of you can speak. I'm curious to hear what your thoughts are on that accusation.
Sunita, you want to go first?
Sure, I can go first. So it was an amazing gift right at the end of 2022 that this case was dismissed. It was a Christmas and New Year's gift all in one. And so first of all, congratulations to all of us and to the truth. Hindus for Human Rights was only about a year old, and we had just hired our first full-time staff person when the lawsuit came. And I couldn't help thinking this was a coincidence. A coincidence that at that moment, when we had the first sort of significant capacity to be in the spaces where Hindu American Foundation had been the only Hindu voice for decades, that was the moment that the lawsuit came, seemed very, it made sense that there was this audacious attempt to silence us. And another thing that was not a coincidence was that it's sort of like the start of a terrible joke that two Hindus, a Muslim, a Christian, and an educator walk into this, not bar, but something like a bar, that they had sued this diversity of people. And Hindus for Human Rights is an organization that's real, and all of us are fighting for that principle of plurality, pluralism, secular democracy, which includes all of us. And so I don't think it's an accident that we were sued as this diverse group. And so it's not conspiracy, it's solidarity, and solidarity won. And it did not silence us because we're principled and mission-driven human rights advocates. And whether in the case of Hindus for Human Rights, it's our faith, or in all of our case, it's our human rights principles, we've proven that when we are attacked, we will not waver and we will speak our truth louder. And I have a lot more to say, but let me hand over to Raju to add his thoughts.
Yeah, thank you all for bringing this group together. First and foremost, I think Rashid talked about the stress on the family. And I think it's a good moment for me to acknowledge that when you are confronted with money power and high profile lawyers, you really need to have the right people behind you, starting with the family. And my family and my wife Geeta, who have been very, very patient, yet very concerned about my safety. I kind of owe this victory to their support to me, and competent lawyers. You heard all of them, and I'm so proud of all of you because I think you have helped us really set a precedent that I will talk about in a moment. What was amazing is our lawyer, Tom Sullivan, was always available at a moment's notice to set us straight, to moderate our anger, which was natural, and steer us to victory. And I really want to thank him and his entire team who have been with us. And what was amazing to me also is how seamlessly all of you work together. I had never met the other lawyers or spoken to them, but yet I knew that you were working behind the scenes to make sure that our work was coordinated. And then, of course, the HFHR family who stood by us, and they realized that we are not going to stop our work because of the intimidation of a lawsuit. They cheered us on and supported us in whatever we had to say and do despite the lawsuit. And I also want to take a moment to acknowledge the very first group that came to support us immediately after the lawsuit were over 400 academicians from all over the world. And I think you owe a special word of gratitude to them in this victory. Couple of other things I wanted to cover also is I think the lawyers talked, and Safa, you've been amazing today. You so very well pointed out to the two footnotes. One about this misinterpretation of the judge about plausible, verifiably false. I have already written an op-ed stating our views, which was published in India just a couple of days ago. And Sunita is going to focus on her so-called lie, talking about parent organizations. So we're not stopping. We are proceeding to put our views on record on both of those issues, because I think our audience, and especially people in India, need to understand the nature of what we're up against in the diaspora. To me, in terms of what next, in some ways, this lawsuit has been a blessing in testing the limits of HAF's power in the diaspora, both through their money and their intimidation tactics. And the very fact that they went after us through a lawsuit rather than meet us eye to eye in the town square was an indication to me right from the beginning that they were in a weak spot. Well, the lawsuit is over. We are in the town square. And I welcome all of HAF supporters and all the American Sangh supporters to join us in the square. Let's talk things out. Let's talk about the difficult issue that faces our community rather than rely on hiding behind Hindutva trolls and legal suits. Does it set a precedence? I absolutely think so. I know the lawyers were very modest in that. But to me, what this is telling the powers that be in India is that there are limits to how far they can use diaspora-based Hindu organizations to do their bidding, whether it's in the halls of Congress or whether it is in any kind of way, including some of them actually going to India to canvass for their party. I think they'll be thinking twice and looking at the limitations of organizations like HAF in acting as a shield against their inhuman policies against the minorities in India. So I'll leave it there. I think at the end of the day, I think this landmark judgment to me represents a victory of honesty and humility over what I see as hubris, hype, and hypocrisy. Thank you.
Amazing ending quote there. Thank you so much, Raju and Sunita, for your stellar comments. And we wish you all the best in your continued human rights work. And lastly, I want to turn to John Prabhudas. John, as a leader of the Indian Christian community and as someone who plays a huge role in speaking out against atrocities in general against Indian Christians and Muslims and Dalits, what was your experience with this case? And do you have any similar thoughts on the impact this will have on Hindu right-wing groups who try to silence their critics?
Oh, sure. Thank you. I apologize for my throat, but I hope you can hear me. I got a bug a couple of days ago, but I will do my best. I thought in the beginning when I got this letter, one of our staff called me and said, "John, did you see this email?" I said, "No, I did not. Do you want to read it?" I said, "No." Then someone from my office called and said they have an envelope, a FedEx mail from a law firm. I said, "What is it about?" And they told me about it. I said, "Ignore it." I never really took it seriously because there was no case. I was surprised at the fact that even a couple of lawyers would agree to send such a letter, leave alone there is any merit to it. So I was not paying attention to it. As a matter of fact, my wife and children till today did not know about it. This morning, my wife sent me a text message of your flyer, this flyer, saying, is that you on that flyer? So that's how she came to know that I'm part of this thing. So that I thank Tom and Andrew, Dan and Andrew for both of them have same last name, so that confuses me. And Dan and Andrew for their sometimes they would call me at 10 o'clock at night. John, do you want this set this way? And did you look at it? It was great working with you, Dan and Andrew, for your support and all through this lawsuit. See, the Federation of Indian American Christian Organizations represent about 1 million plus Indian American Christians across the United States. What we came here to, how we came about is to fight exactly the same forces back in India that are destroying, intimidating, causing physical damage as late as day before yesterday. Christmas, New Year gift, a bunch of radical Hindu nationalists, the same groups that the Hindu American Foundation goes to bed with, the same groups that they bring the speakers from those same groups here and give them a platform to speak and arrange their travels and stuff. That group barged into a church, a Catholic church in a place called Chhattisgarh, and completely trashed that church. And 3 policemen were posted as a security. They were beaten. And one of the policemen was bleeding when I saw the videos. I'm sure most of you have seen that. We are fighting the same forces back in India. I was surprised to see they are so active and well-funded to go after. If they cannot do it physically, like Roger said, they're coming after, trying to silence us, trying to intimidate us through lawsuits and stuff. As a matter of fact, I found it very, very humorous that there was a flyer I was sent some time back from somebody that said this particular organization was hosting a workshop, a legal workshop, to teach others how to sue and silence their opposition. Isn't it ironic that they come to this country and do such a backhanded policies, backhanded tactics to silence people who are speaking for those who cannot defend themselves in a country where 80% are of one religious faith and a small minority that's trying to survive. So this is a very aggressive mode they are in. I was even surprised, like all the attorneys have pointed out, how they have spun this thing to claim some kind of a moral victory, which is beyond my imagination. I would just only pity them for their helplessness, and they should learn something from it, and not at least seen as supporting this extremist agenda in American soil. And my caution to Washington is that this is a dangerous trend and a dangerous ideology. It is taking root in this country with 4 or 5 million immigrants coming from India. It is a fertile ground for them to sow this hatred among that community. And these organizations and network of these organizations are doing an excellent job of sowing that hatred. Now, that was shown, another example that we just saw 3 weeks ago in Texas, Frisco, Texas, an organization that openly calling for having a fundraiser gala, openly saying that one of their agenda is to demolish churches in India. Now, if that kind of venom is allowed to seep into this society, it's not going to be a fight between 2 immigrant ethnic groups in America, it's going to be a major problem for American interest, American idea, the idea of America. And I think the law enforcement has to take it very seriously and take it from here. Thank you. I'll stop at that. Any questions I'll take.
Thank you so much, John, for those powerful remarks. And I'm actually really glad you brought it back to the number of active right-wing Hindu groups that are causing trouble for people directly on the ground in India. So these two groups of people are not removed at all. They're actively trying to harm people who are marginalized in India, and often the consequences are much greater than what they are here. So I appreciate you bringing that up. And I have one more question for Mr. Ahmed. So as executive director of IMC, you have also been a firsthand witness to the way IMC as an organization has been targeted by the Indian government. We have had police in India file charges of terrorism against this organization, and we have heard the senior ranking officials of the Indian government itself try to claim that IMC has alleged terror links, things, blatant falsehoods and things like that. What are your thoughts on that, and how do you think this lawsuit pushes back against those allegations that IMC has been seeing from India?
I think most of, at least panelists here and attorneys might have already understood it. Maybe even those who are listening to this briefing may know that the current regime, not the Indian government overall, but the current regime that runs India is just HAF is just part and parcel of it. It is the whole same ecosystem. So whatever we do or anybody does, whether IMC or Hindus for Human Rights or Fiocona, or even Audrey from academic perspective, whatever she does, if it undermines their narrative that India is a secular country, it's a democratic country, they have a they have a serious problem with that, because they want the rest of the world to believe that India is the same India that Gandhi has fought for and given that vision of secular India. Gandhi's Hinduism was secular, not necessarily the Hinduism of current prime minister. So again, the silencing tactic, what you refer to that IMC was charged with terrorism. It's actually just one tweet. We had a tweet protesting about a masjid that was demolished, and a journalists went there to investigate, and we had expressed our opinion on it, and they filed a case under UAPA. It's an extreme draconian law, UAPA, and they added IMC's tweet in it among over 100 tweets. So it was not necessarily direct charging IMC as a terrorist organization. It is just the tweet they thought was they didn't like the tweet. So Indian government current Indian government, the current regime of Indian government is trying to silence diaspora everywhere. It's happening globally. Even in UK, you may have heard there was actually a march of 300 Hindus who are now in British England for some time. They actually marched through Muslim neighborhoods and all kinds of slogans and all that. So this is a pattern. It is not against IMC as such. It is about anybody who is amplifying what what John was mentioning, the violence, the unabated hate that goes on. Actually, what was really sad, John, about the church you were saying, was they demolished the church, but they started out with destroying the statue of Mary, one by one. So this is, again, I come back to the legal analogy. They're trying to do to American society what they are doing to India there. And as John pointed out, this is no longer a Indian diaspora problem. This has already become an American society problem. But what is very concerning is that American society sees Hindu American Foundation as extension of Hinduism and equates it with the Gandhi's nonviolence and all that. And they get away with that. And whenever Hindus for Human Rights, who tries to distinguish that, they want to silence them. So Audrey, as an academic, she knows much better how to address this. We are doing our job as a community organization. We are not necessarily a professional human rights organization. We are a victim group. I would be doing something else. Safa would be doing something else. Our board, everybody would be doing something else. But we feel as a community, as Muslims from India, that we have to speak up. We have to do something about it. So that's why we are laser focused on India, on Indian Muslims, on Indian minorities, and anybody who supports us, like Hindus for Human Rights and Fiacona. So we are marching on. This Hindus for HAF lawsuit has not stopped us. Actually, we have done a lot more work in 2022 after the lawsuit was filed than we did before. So we are marching on. We are not deterred. We will do all that we can do and more. And we have great partners in us like Fiacona and Hindus for Human Rights and many academics who are doing their work. Sometimes it helps us also. So thank you for that question.
Thank you for that answer. Appreciate all the detail. And Audrey, really quickly, I know everyone else has had a chance to thank their lawyers who are here. But if you had a message for your lawyer who wasn't able to join us today, would you like to say a few brief words?
Absolutely. So I sort of had two sets of lawyers. I was co-represented by Davis Wright Tremaine, which is a big law firm, and as well as the Cornell Law School First Amendment Clinic, which was great. They were both fantastic. My lawyers were amazing. Let me say two things in particular. One, it was a real pleasure to work with some of the law students at Cornell. Josh mentioned, even a first-year law student should have been able to win this case. And in my case, yeah, some of them actually did. So that's really great. And that was a true pleasure for me. The other thing is just a special shout out to my attorneys. Really understood the need for me to continue my research and to not just, sort of keep my lips closed until the end of the lawsuit, which is standard advice in litigation, right? Just stop speaking until it ends. That was never an option for me. And I really appreciate my attorneys sort of guiding me through, what that process might reasonably look like.
Thank you so much. I appreciate you saying those words. And I would also like to quickly go back to our attorneys. I know I want to be respectful of your time, so if you do have to drop off at any point, that is totally fine. But we do have some incredible questions that have been asked in the Q&A chat box, so I wanted to pose those to our attorneys right now. The first one I want to ask is, out of this experience, what guidance can you offer to people who wish to publicly criticize Hindutva behavior in the United States? The worry is that even though this case was dismissed, that others could still be subject to a lawsuit, even a frivolous one, which could stifle speech for fear, out of fear of an organization having to hire an attorney and defend them. which would be well beyond their resources and bankrupt the organization offering their dissent. So for our attorneys, any thoughts and guidelines for people who might want to speak out but have this fear?
Tom, you want to take that as the most experienced First Amendment person on the call?
Yeah, sure. So, the first is a bit of unfortunate news. You can't stop yourself from getting sued in a, if somebody wants to sue you, they can sue you, as this lawsuit demonstrates. You can only be so careful, and even if you do everything right, as the defendants here did, and the case gets dismissed very quickly, it still, takes up a lot of time and energy and away from your advocacy work. So part of it is that, unfortunately, there are people who are going to try and bring lawsuits no matter what you say. But in terms of guidelines to try and make it somewhat safer, I do think here the statements at issue were statements of opinion. And I think that was really, key here is one of the grounds on which it was dismissed. I think, there are statements that are, if you don't know that facts are true, it is good to avoid making factual statements. I think you're on much safer ground, as everyone did here, speaking more in a way about opinion. It's hard to say that, any individual statement without knowing what the context is going to be or knowing what you're trying to say. The other thing I would say is insurance can be your friend. There is both if you're an organizational entity, you can get insurance that includes coverage for claims about defamation or other content related claims. Individuals, if you have a umbrella insurance policy and you're speaking in an individual capacity, often an umbrella insurance policy will include coverage for some sort of defamation claims. So, be aware of that. I think that can be helpful in terms of trying to mitigate some of the cost if it were to happen. And the last thing I would say is there are states that have better laws and more helpful laws than DC. DC itself has very helpful laws, but the way they've been interpreted, they don't apply in federal court. And so, I do think something that groups like these should be thinking about advocating for is better protections. They're called anti-SLAPP laws that provide defendants greater protections in defamation suits, both media organizations and advocacy groups and anybody in a lot of cases who are talking about public issues. So I do think anti-SLAPP laws are very, very helpful where they apply. There's good anti-SLAPP laws, for example, in California. There's now a good one in New York. There's been some movement trying to do a federal anti-SLAPP law. I do think that's something that could be very helpful if they were to be passed, to provide additional protection for people who talk about issues that are going to be controversial, issues that could make people angry, even if you're saying something that's entirely true. I think that's what I would say.
Thank you so much. Appreciate the little bit of legal counsel there. I'd like to go to Josh right now. I think everyone has mentioned this so far in their commentary on the lawsuit itself, but it seems to be perplexing to a lot of people that have sued the talking heads, per se, in this article, being the defendants, but did not sue Al Jazeera itself. So what do you make of that?
Obviously, we can only speculate. In general, people prefer to litigate against counterparties who have fewer resources. There is an unavoidable financial consequence to litigating a case to any extent in the U.S. The cost of doing that in general is not going to be borne very well by people who don't have a ton of money. Interesting to note how many times HAF described its supporters just pouring money into the HAF coffers to support this litigation. So if you're making strategic decisions about who to sue and one potential defendant is funded by Qatari government money, that may not be a very appealing prospect because the resources will be there on the other side to fight until the very end. If you're looking at suing people who you think may not be able to come up with decent lawyers at all, the litigation approach may give you the idea that there will be practical leverage to drive things in a way independent of the litigation process if you sue those people. These are the kinds of considerations that generally come into play. I think it would be naive to presume that those considerations were not in play to some extent here.
I appreciate that answer. Going back over to the First Amendment expert, Tom, is there a potential to countersue for damages of the sort that Audrey mentioned with regards to her research and that being, something that she will always be a part of? Or is there a way to do anything further to impose a cost on HAF or other similar organizations for taking part in a SLAPP lawsuit?
So the anti-SLAPP statutes I mentioned earlier, SLAPP is an acronym that means Strategic Lawsuit Against Public Participation. A lot of SLAPP statutes include a provision to recover your attorney's fees. A reason this case was filed in federal court as opposed to in DC, it's not state court, but the local court in DC that's not a U.S. district court, is in part to avoid presumably to avoid the anti-SLAPP statute that exists in DC that would have made a recovery of fees easier here. That it can be in states in which there is a good SLAPP statute, anti-SLAPP statute, that can be a significant deterrent to bringing a frivolous defamation claim because there is often a mandatory recovery of fees in case in which they apply. Otherwise, the recoverability, generally speaking, in U.S. federal court, it's very hard to recover fees as a prevailing party. Usually, everyone sort of bears their own fees and costs is the general rule. Not always. If it's a particularly frivolous claim, you can bring a sanctions motion. You can recover some out-of-pocket costs if the case goes on longer. But it is a deterrent to people because in a lot of cases, you end up bearing your own fees and costs.
Thank you so much for the answer. Last but not least, I want to turn back to Dan for our final question. And I think this is the lingering question for a lot of our viewers. What happens next? Is there a possibility of an appeal, and can there be a countersuit? What do you think is the answer there?
Well, first, as to an appeal, HAF has 30 days from the time of the decision, essentially, to appeal. So I'm not remembering now exactly the date the decision came down, but in any event, we'll find out at the later this month whether or not they're going to file what's called a notice of appeal, and that just means that they intend to appeal, and then there'll be a briefing schedule, and it would go up to the Court of Appeals for the DC Circuit. So they have the ability to do that. They may not. So I can't comment on whether they will or they won't, but that's still a possibility. I don't think there's much possibility for, there's no possibility for anything further at the district court level. Usually, or often when a case is dismissed on the pleadings like this, there's an opportunity for the plaintiff to try to replead, essentially, to try again. But Judge Mehta, this is another point, incidentally, that just shows, I think, how ridiculous the attempts are to extract some kind of moral victory for HAF from this. Judge Mehta went out of his way to say that a final judgment would issue on the basis of his order, not suggesting much willingness to entertain any repleading. Which, for the first motion to dismiss is not usually how it works. Oftentimes the judge will say, well, wait to see whether or not there's any attempt to replead. But it was clear he didn't think there was anything to be had here. In terms of a countersuit, I mean, I would go back to what Tom said. I mean, there are defensive measures to impose some sanction on a party for bringing a lawsuit that is either a SLAPP suit when you've got an anti-SLAPP statute available, or a frivolous lawsuit in general in court. But it's difficult to make an affirmative claim out of somebody suing you. It has been done, but usually in sort of very extraordinary situations that I'm not sure this would rise to the level of. So, again, it's obviously it is as wonderful as the vindication is, and it is very wonderful. It's also frustrating sometimes to think that they were able to put everybody through all of this. But I think the hope is that, as I said earlier, this will be a cautionary tale for other entities before they decide to pour money into a fruitless and frivolous effort like this. And I'm hopeful that the next step really is for all of the defendants to do what they've said, which is to not be deterred and show that the attempt to silence you all has failed, which is really the best way to deter this kind of thing. So,
lovely ending on a silver lining. Thank you so much, Dan. Thank you to all of our attorneys for joining us here today. Really appreciate all your time. Yes.
For just 30 seconds.
Of course.
I again want to thank all the attorneys. I want everybody to be cognizant that I know sometimes the legal profession in America is tainted by, quote unquote, the ambulance chasers. But these attorneys have, at least for me, have built additional confidence in American legal system. And here, all the attorneys here have taken this case as pro bono. So, and this is, I don't know how many, hundreds of hours, if not more, thousands of dollars of value for the legal defense. These attorneys individually and their law firms have committed and saw through successfully. So on behalf of everybody here from IMC board and volunteers and staff, I thank everybody for taking up this case. We didn't have to spend our donors' money, whereas HAF might have done a lot of money spent their donors. Thank you.
Would like to echo that. Thank you so much to these attorneys for all your work on this case. And as just a last final question, Sunita, I'm going to pick on you real quick. So for you and Raju, you've dedicated all this work and all this time and effort into spreading the message that Hindu American Foundation is not the only organization that speaks for American Hindus. So as we close off, let's do some food for thought. What is your message to the Hindu American community?
Well, just exactly that Hindu American Foundation and all the other Hindu right-leaning Hindu organizations that are in this country and the diaspora, they have the right to exist. They enjoy the same First Amendment rights that we have defended through this lawsuit, and we've won. But so do we, and we present an equally valid alternative path for Hindus of conscience in India, in America, and all around the world. And we invite Hindus all around the world to join us. We are creating chapters in different countries, Australia, UK, Canada. And one thing, a lot of Hindus for Human Rights work is advocacy, and a lot of advocacy is communications. And the lens that we use for our communications is really myth busting, because this lawsuit is just one of innumerable examples of the currency of the right, especially the Hindu right, which is distortion of truth. So what we do in our advocacy is to bust the myth and tell the truth. And so that's what we'll continue doing. And if you want to learn what the true story is, please come and join us at Hindus for Human Rights. And I want to say also, since you've given me a chance to thank the lawyers, I want to add my thanks to our lawyers, Tom and Joe and the team at Ballard Spahr, but also want to point out what look worked for Hindu American Foundation and what message Hindu Americans want to take from this. The law firm that they chose to retain, spending presumably hundreds of thousands of dollars, is a law firm called Harder that has represented both Trumps, Harvey Weinstein, and Roger Ailes. That must have been a look that they would have workshopped among their leadership and decided was the best look for their base. So if you are a person who cares about democratic values and inclusive secular democracy, whether it's in this country, America, or in India, and you're a Hindu, I invite you to think about that and make your choice about which path of being and living as a Hindu works for you. Thank you, Safa.
More power to you, Sunita, and to Raju, John, and Mr. Ahmed, and Audrey. Appreciate all of you so much for being here. Also, again, I think we can't say it enough. Thank you so much to these attorneys. More power to you as well. And as we close up today, I'd like to do a little virtual toast, halal toast, if you will, to the friendship of these defendants and the attorneys. May you never have to work together again. Thank you. Thank you all so much for joining us, to our audience as well. I would like to very quickly thank all of our co-sponsors for this event. This briefing was co-sponsored by Genocide Watch, World Without Genocide, Indian American Muslim Council, Hindus for Human Rights, International Christian Concern, Jubilee Campaign, 21 Wilberforce, Dalit Solidarity Forum, New York State Council of Churches, Federation of Indian American Christian Organizations of North America, India Civil Watch International, Center for Pluralism, International Commission for Dalit Rights, American Muslim Institution, Students Against Hindutva Ideology, International Society for Peace and Justice, the Humanism Project and Association of Indian Muslims of America. I sound like an auctioneer, so I think it's time to end this here. Thank you all for joining us and have a great rest of your